We've got a second Amicus Curiae brief to look at here. But the thing with these briefs is that I found the second verse is really the same as the first. So one of the first things that really stands out for me about this brief is how opaque they have made the identities of these amici. It's just kind of an odd choice if you are putting yourself out there as someone who has helpful information to provide to the court to help them solve a high-level legal dispute. Then you would think you should tell the court clearly who you are. But they don't identify themselves on the caption page. They just apparently list the identities of the signatories in an appendix. That appendix wasn't provided to me. I haven't even seen it. So I don't even know who the specific identities of the people are who authorized this. But we have to go, few pages into the brief, past the table of contents, table of authorities, all that type of thing, to even kind of find out why are you here? And so they describe themselves as three categories of amici. First, organizations that support a vibrant First Amendment. They're concerned about protecting their ability to engage in reporting facts and opinions regarding important current issues, which is threatened by the verdict in this case. Interesting, because this case doesn't involve a reporter. But let's continue. Second, civil rights and women's groups have joined to address the significant diminution of reporting of abuse against women as a result of this verdict. Okay. And third, groups assisting persons who have been abused, especially involving intimate partner abuse, have joined to protect their clients from the devastating effect of this verdict. So basically, people who have some grievances, apparently with the optics of this verdict, don't like the fact that a woman was called out as a liar and found to be a liar in a court of law. They don't like that. They think that is a problem for people who want to truthfully report partner abuse. So that's fine. We'll take them at face value with their good faith. That is what the court is going to do. So let's go ahead and continue. So of course, I always look first at the table of contents. That's the court's first impression of your case. And what we see here is honestly pretty underwhelming. It manages to achieve a couple of things quite effectively. One, it makes it very clear that we are just going to be reading the same thing that we already read in the first amicus brief. And it also makes it clear that just like that first amicus brief, this one also is not appropriate amicus briefing. It is not looking at broad issues of law, broad questions of law that have the potential to affect the interests of the folks that they are purporting to represent. They're arguing about the version of events that Amber Heard tried to sell to a Fairfax County jury and lost unanimously. So it's a private dispute. This is not the type of thing that Amicus Curiae are typically supposed to get involved in a case to litigate. That's not their role. Their role is to help with big picture issues, broad application of legal standards types of questions, not to complain about, whether they think Amber Heard should have won on the facts. So I've also, of course, talked about the headers a lot. We have some just really bad headers in this one. Oh, the trial verdict is inconsistent with First Amendment principles and precedent. This is awful. I mean, this is so bad. It's just conclusory. It tells you absolutely nothing except I disagree. I disagree. It doesn't tell you what it's inconsistent with, which principle, what precedent are we going to talk about? Is there anything with any specificity that you could offer me here that would perhaps give me a signpost to why I am interested? But no, we just have basically what are a series of argument points and not explanations or reasons, which is really what your brief needs to be offering to the court. The court already knows that you disagree. That's why you're filing a brief. So telling the court that you disagree is not particularly helpful. This is why you need to use that magic word, because the trial verdict is inconsistent with First Amendment principles and precedent, because it would be very helpful at this point. In fact, as I look through the rest of the headers, I think they may have managed to not write a single decent one. These are all terrible. Republication of the headline written by a Washington Post staffer cannot be the basis for liability. Why not? This is one of those things where it's an extremely fact-intensive question. What are the circumstances of the republication? We know from the briefing that's already been done on this issue what the standard is. The standard is basically, has anything been added or modified when we're talking about a retweet of something. So whether it counts as republication within that sense is going to depend on the facts that were presented at trial. So essentially, again, what you're arguing here is that the evidence is insufficient to show that it meets that legal standard. So if you want to convince the court of that, you need to focus on what possible evidence there is against you, because the court's going to find it, and you need to be prepared to rebut that and explain why does that not, despite maybe looking like it at first glance, meet that republication standard. So in this particular case, the argument is quite clear. She added language to her retweet. I published this today. And you need to basically focus your argument, if you're going to try to make one, on why isn't that enough? So this very general, conclusory, boring republication of the headline cannot be the basis for liability. Oh, this is just trash. The court, not impressed. So then once we get into what passes for substance in this brief, we see this is basically just a more rambling and kind of incoherent version of the first one. It says, by and large, the same thing. It sprinkles in a few magic First Amendment words. But by and large, it's just the same series of grievances about the optics of the verdict. And this idea that somehow men who are wrongfully accused, shouldn't have the right to recourse in the courts because, it might look bad to political hacks like these. And so, they're just trying to argue that there's all these social consequences of the verdict. But to be quite blunt, when it comes to the court, they don't care. If you aren't giving them a legal reason why this verdict is flawed, then they don't care. That is the consequence of the legal system, not the consequence of the verdict, not the consequence of the Court of Appeals. It is the consequence of Amber Heard's decision to lie about being abused by Johnny Depp for many, many years and end up where she is today. So because this is, again, largely just a rehash of the same thing that we already read, it cites many of the same cases, it makes a lot of the same points. I'm not going to go through a lot of the content in detail. I am just going to highlight, though, a couple of things that I saw that caught my interest. So one of the first things that caught my interest was here on page 3. And the reason why it caught my interest is because it repeats one of these little errors, I guess, that I noticed in the first amicus brief as well, which raises some question in my mind about, who exactly did do the writing on these. But it's here in the first full paragraph, first sentence, the argument of Mr. Depp's counsel to the jury relied upon many assertions that are nowhere within the four corners of the editorial at issue or reasonably derived therefrom. So ultimately in this brief, they are going after, the argument that these statements should not have been considered potentially defamatory at all as a matter of law. But they're focusing here on Johnny Depp's counsel's argument to the jury, Ben Chew's closing argument. And the reason why this stands out to me is because nobody objected to Ben Chew's argument. You have to object to these things in the trial court if you want to try to raise it at the Court of Appeals. If you don't object, you have waived your objection. So this didn't come up then. Whatever gripe they may have about it now, it is not an error that the court is going to consider. So this is real similar to in the first amicus brief when they took issue with failing to give the jury instruction defining abuse. This was not designated as an assignment of error by Amber Heard. It's not argued in her appeal. So we are beginning to now see a theme emerging with these amicus briefs where they seem to be the dumping ground for all those additional grievances that didn't make the cut for Amber Heard's own briefing, but nevertheless, just strangely seems that these amicus can't quite let them go either. The next thing that was just funny as hell starts here at page 12, and it's when they start getting into this very smarmy takedown of the circus that was the trial process. To say that the Depp versus Heard trial in Fairfax County Circuit Court and its surroundings was a circus is a gross understatement. Oh, the drama. This is hilarious to me because you're purportedly representing media organizations, right? Isn't that what you said at the very beginning? That these are folks with an interest in publishing details, about maybe things like lawsuits, public cases. What do they call that? Like OJ, I think, was like that too. What did they call that? Was it a media circus? Yeah, you know what? I think it was. Oh man, it created an atmosphere more appropriate for a trivialized wrestling match than a court trial impacting people's lives. Wow. So they really didn't like the environment in that courtroom. You know who else I bet really didn't like the environment in that courtroom? But Amber Heard didn't really like it. So, of course, seeing the media project its sins onto everybody else who's doing the things they wish that they were doing is always entertaining. Where this really reaches its pinnacle for me is on the next page as they continue. The grand conclusion, the reason why all of this matters is because these would chill speakers who should be protected by the First Amendment. Yes, that's right. We're back to First Amendment advocacy here in the context of apparently taking issue with the public attending a public trial. A right that is protected by the First Amendment. That's very peculiar. Maybe it's just that we're not supposed to talk about the case. Is that it? We can watch it as long as we don't say anything, have opinions? Is that consistent with the First Amendment? Yeah, I'm not really sure how these people reconcile what they are trying to get the court to think about this process here with this ostensible reverence for the First Amendment. It protects a lot of things. And I feel like if you like one, you really need to like them all. So yeah, public trials. Public's right to attend is protected by the First Amendment. Amber, get used to it. So for an Amicus Curiae brief, which is supposed to be helping the court with these big picture issues of law, this brief is remarkably light on law, really at all. It takes us, almost 21 pages before we get some kind of substantive citation beyond just, some kind of cursory nods to the standards of review that apply to these arguments that they're making. And they choose, once again, a rather interesting one, a New York State case. Okay, it's not going to be binding authority in the state of Virginia, but they certainly can take account of it if they want to. It can be persuasive. But the problem is they are arguing that this has something to do with retaliation, the concern that this verdict is going to cause people to not want to report abuse. And so they rely on this Sagai case to support this argument that somehow there's going to be a disincentive now. But the problem is, when you go and look at Sagai versus Carriga, what does it tell us? The very first thing that this case is about. This appeal raises the issue of whether a sexual assault victim may be subject to a defamation suit based solely on her report to the police of the incident. This is a case about litigation privilege. These types of statements are protected. You get to make statements to the police and you can't be sued for it. You get to make statements in a protective order hearing and not get sued for it. But you don't get to write an op-ed and publish it in the Washington Post and not get sued for that. You see the difference? Not only does the brief not really address the law, but when it does so in a way that is distinctively unhelpful. And I'm going to point in particular to this thing they did on page 31 with Pendleton versus Newsom. Now, this is a case that Judge White cited in his opinion. It is one of, looks like a landmark case in Virginia for defamation by implication. We've seen it come up a lot. We are going to see it again. It's probably going to be in the opinion. So the court is going to pay close attention to this case. Here's what the amicus have to say. They say, any matter that can be considered in evaluating the statement must be within the publication itself, or within the public's knowledge in the immediate past. See Pendleton versus Newsom, and then give us the case citation. So they are asserting a rule here that they are using this, what's called a C cite to Pendleton to support. So a C cite is different than a direct citation because you're basically not claiming that this content is literally in that opinion. You're saying it can be inferred from it. And so it's common to use C cites when you're making arguments about, for example, a pattern between a series of cases where you want to say, well, there's been this implicit understanding that, X. And so here are examples of cases where conclusions were reached that would allow us to make those types of inferences. So it's an acknowledgement that there's no direct support for this proposition. But then you just once again, go and look at Pendleton versus Newsom itself, and you just have to really wonder where they're coming up with any of this. Because there's nothing in Pendleton versus Newsom that would lead to the conclusion that the court was setting up any sort of rule like this. What Pendleton versus Newsom actually said was that because Virginia allows defamation by implication, evidence is admissible to show the circumstances surrounding the making and publication of the statement, which would reasonably cause the statement to convey a defamatory meaning to its recipients. Period. You get to look at the circumstances when the statement was made. There's nothing that says, oh, that only applies if the statement was recent, or that only applies if there's a close period in time between when the statement was made and when the comment was published. And there's certainly nothing here that suggests that when you signpost in your op-ed, I'm going to be talking about 2 years ago when I made all those defamatory claims against my ex-husband, that somehow, wouldn't be a circumstance that the jury would be able to take into account. Yeah, this is not a good faith use of this type of argument, this type of citation, and it's not the type of thing that the court is going to be pleased with. The court is all fine with amicus getting involved to try to move the law in a particular direction. They're fine with it being politically motivated. I mean, these things are sort of normal. But you need to honestly engage with the state of the law as it is and speak to that, because that's what the court is going to do. Whatever crazy fantasy law in your mind you have cooked up that you think Virginia law supports, you're not going to share that perspective with the Court of Appeals. So it's a very, very bad argument to make. It's a bad position to put yourself in. This is, from my perspective, really a credibility killer. Honestly, guys, this is about all that there is worth looking at in this brief. The rest is just a bunch of the same relitigation of issues that were for the jury to decide, supported by selectively cherry-picked versions of, facts and evidence without acknowledging the counterpoints that were presented, and just basically hiding behind this parade of horribles that they march out to try to suggest that the sky is going to fall if this private dispute between Amber Heard and Johnny Depp doesn't somehow get decided the other way. It provides no substantial legal justification for doing that. It falls prey to the same problems that we have discussed in other videos concerning things like having to demonstrate the harmfulness of the error and not being able to do that. So it's just more of the same. It's really the first brief all over again, run through the washer to spin it around and get things in a slightly, I guess, different wording. But it just rambles and rants and does not present a persuasive case that there is, frankly, any substantial public interest here that the court needs to be concerned about at all. Ben Chu filed an opposition to these amicus briefs. I do have that, and so we'll be taking a look at that next. We've also got our first response, our first appellee's brief. Amber Heard has filed her response to Johnny Depp's brief. So this is going to give us an opportunity now, like I promised, to go in and do some deep diving into the legal questions. So those will both be coming up. Stick around, and I will see you soon.